We have for you a star-studded panel for after lunch. No worries about anyone not being excited by what's being said here.
Pressure's on.
We have 2 representatives of state government, 2 representatives of investigative journalists, and a lawyer. We really should have put the lawyer in the middle.
We have 2 lawyers.
Pardon?
We have 2 lawyers. I'm also an attorney.
But you're,
There you
well,
There you go.
because the lawyer always winds up mediating between the public and the government. And that may be one of FOIA's great downfalls, is putting the lawyer as the communicator between. We're very fortunate, though, to have these representatives to talk about state government. Is it just a difference in scale? Are the problems the same? Is it a difference because there are 50 or 51, depending upon how you count the District of Columbia, state governments, each of which has different laws? What we hope to explore in the next hour or so is how is it the same, how is it different, and what can we learn from what the states have done that perhaps the federal government hasn't been able to. And one of the problems of relying on electronic media, here we go. James Henderson from Maine is going to be our first presenter. James?
Thank you. A little background from me, maybe. Not only did I used to teach government, so to speak, in university level, and but then I've been in the legislature of Maine, and in a couple of local governments, which I am now since I'm retired from most of that other stuff. And then I was in the bureaucracy of the Secretary of State's office and got booted over to the archives and was in the archives for about 20-something years. So I've kind of seen these kind of things from several different perspectives, and hopefully this will be of value. Since we're supposed to discuss anything that is unique to seeking records at state, local, and tribal levels, so that is the question posed, is there anything unique? And I think generally speaking, at least this is from my perspective of a little state, that it is a matter of scale, and certainly it depends. So, California, New York, and several other states are clearly, as from the outsider's perspective, as big and as complicated maybe as the federal government, especially if you're dealing with any particular part of the federal government. But I think we got to remember that there's still a huge number of states that are pretty modest in size, and thousands of local units that are, very small and even comfortable up to a few tens of thousands. But even in those areas, you can get to know people. And the tribes, of course, present a different issue, which is their autonomy, a degree of autonomy. In Maine, we have a state and tribal commission, kind of a combined commission. And while I was archivist, I was trying to find out, whose records are these of the commission? And we never were able to pry them out of the commission because the tribal folks kind of felt that was their territory rather than the states. Anyway, I'd like to talk a bit about approaching local governments and state governments in terms of building alliances, and then kind of how people might want to massage or approach or survive their contact with the custodians of the records that people are looking at. A lot of these, and eventually talk a little bit about electronic records, although again, depending on the scale and of which records you're looking for, there are different issues from the previous conversations, which seem to be exclusively focused on the electronic records. But people in their daily lives still, amazingly, submit things in paper, or they're looking for things that were in paper and are of interest to them. In the case of developing alliances in the states or in the communities, there are a variety of groups, and you can start with the basics of the League of Women Voters and your Library Association, all of whom are pretty rabid in these areas. But there are also freedom of information coalitions, which there are 56 of them in the 51 jurisdictions, so there's a little duplication there. But these are formed often of members of the media, but also of academics and even government folks who are interested in open government. So the Freedom of Information coalitions do a lot of the heavy lifting sometimes in either bringing suits or attempting to pry open the right-to-know laws in the various jurisdictions. So I just encourage you to put that on your hit list of resources. Another is the Reporters Committee on the Freedom of the Press, which I think Mark knows more about this than I, but nevertheless there are websites where there are resources for each of the states, at least for the reporters, and how much broadly that's available, I'm not sure. There's also the state, and I'm looking for my own little notes here, but anyway, the state archives, the Council of State Archivists, I should say, have a website which recites the laws, especially on records management requirements, which have a lot to do with whether your custodian can find the records that they're looking for. One of the things I think that's important, and it may be again as a distinction with a smaller scale of government, if you're looking at that, is to support the training and education of the folks that have the materials. A lot of times they literally don't know what the right-to-know law means or some of its variations. And one of the things that the National Archives, state archives have tried to do generally, and these Freedom of Information coalitions, try to educate the county clerk, the town clerk, the local officials, making it, again, as folks were saying in the last session, in their interest to stay out of trouble and not get embarrassed by picking a fight with some newspaper or whatever if it's really not necessary. So if in your particular jurisdiction, if you notice that there is some kind of a training or support system developing, supporting that would probably be in your long-term interest. One of the other related element is that the FEMA recently gave the Council of State Archivists a grant of a couple $1 million to develop training modules for local and state government and tribal government officials for what are called essential records. Those are the records that you need for continuity of operations in case of various and sundry disasters. But one of the elements of that training, which is now ongoing after being under development for a year or so, is to acquaint people, first of all, with just basic record management techniques that they need in their own interest, but mostly for this Essential Records program. And then the second is to get them acquainted with what these records are that they are likely not only to need to maintain the government if something happens, but some of these essential records are also those permanent records that are essential to people's livelihoods and needs, such as land records, birth, death, marriage, and a lot of other critical records that are just important for the society to function. So again, that training is going on now, or is about to go on, and to the extent that you become aware of that and support it and urge your jurisdictions to get involved in it, the more likely that the folks are going to be able to serve you when the time comes. I guess another element that I want to talk about is to know the law. It seems pretty basic, and maybe all of you do, but most states have some kind of sunshine law, right-to-know law, freedom of access law, whatever it is. But the practitioners often go on common sense and practicality and whatever they used to do for quite a long time. So the tricky part is to be diplomatic about helping them understand it. Now, this is not so much training, but it's that you're there at the desk and you got to say, you're asking me why I want these records. Maybe you didn't know, but the law mostly says that I don't have to tell you, but you may not have to say it that way. because the reasons for asking for something is usually not a requirement to get the access. And for good reason. I mean, it's not like, by the way, I want to make sure that Counselor X gets roasted once I find this information, or find the embarrassing information. And the other, I guess the other little bit of just nitty-gritty advice is don't be afraid to, and as I'm sure many of you don't have a problem with, but maybe some in smaller communities, to appeal to a supervisor and to request a specific citation of a law if they say, oh no, that's confidential. And I'm sure many of you face this situation where the person gets nervous that you want this information and they just don't think it's right that that be public, you know. So again, being aware of that and being able to point that out is something of value. Now I'm talking this person-to-person thing and not the electronic records yet, but I promise I'll get there pretty quickly, I hope. The other issue, of course, is distinguishing between the records that have no confidential information and records that have confidential information. And very often local custodians will think that if a record has confidential information, it's a confidential record and you can't see it. Not the case, generally speaking, that they have to redact it, you know, as we talked about earlier. But again, there's often a local tendency to just segregate those things that have sensitive information. So just got to be aware of that kind of issue that you might face. There are a lot of delays in these issues, in these areas, and some of them I've just recited because there are roadblocks that are put up. With respect to archival records, having been the archivist, there are some distinctions here too, as with the National Archives. But in most of the state archives, you know, 90% of the material is in paper format, and it's old stuff, and it's really not going to be something that's going to be out there immediately. When I was in the archives, we were trying to figure out how are we going to do this, how are we going to put things online or whatever, and it was basically, we decided it was going to be an on-demand basis. If people are interested in X, we'll put up the X file, so to speak. And if not, you know, we'll deal with individual requests. But to try to get what amounts to millions of records, even in a small state like Maine, all out there, of course, is pretty impossible. And of course, they're all fake records, as we've been using that term earlier today, because you can't really have a hologram to bring that out. But on the other hand, one of the reasons for delays with respect to archives and records management is the issue that was brought up earlier too, of authenticity. Just putting something out there is not necessarily, unless it's from a trusted source, going to be the authentic record. And so that's why it's so important not to rely on, say, WikiLeaks documents or some other documents that come from some other source, because you have there's been no chain of custody, so to speak, in that case. You don't really know whether that was the same cable or whatever it was that you might get if you were to get it from a trusted source such as the agency itself. How am I doing?
Okay.
A minute or two more in which I would just say, as people were discussing indexing earlier, one of the problems is whose index, whose terms? How are you going to know if we put it under the name, you know, of whoever Pooh was lived under the name of so-and-so, I forget, out in the woods. But nevertheless, people may not use those same terms. So one of the things that archivists do is try to use, as the State Library of Congress does, standard subject headings or standard terms. And yes, there may need to be a thesaurus to match those up. So when it gets to archival records, that is one thing that should be accompanying whatever archives are going to be posting on the internet, because they're going to have those standard terms that may assist in the discovery of these records. But as part of getting even those things out there, and I'm talking about the old paper that is the non-born digital, is it takes a lot of physical work to go through them, to determine what those terms are, to make sure that they are connected in their appropriate groupings and so forth. It's called processing, which is a long story. Another aspect of the context in these things, again, whether it's national or state, is the context that we talked about earlier, but that also means a record by itself without any context is really quite meaningless. You don't know where it came from, who did it. And it may not be because it's next to the other record that is relevant. It could be some record in a completely separate space. So to the extent to which archivists can work those things through and provide the context, to that extent, when the information becomes available, it will be more valuable. Finally, quickly on the just on the electronic records area, that's obviously new to states as it is to the feds, and there's very little, well, I'll just say relatively little, born digital records that are like immediately accessible. And certainly not in the email systems. And I'll just give one anecdote and quit because there are plenty of things to talk about. Is several years ago, the state of Maine was sued, as states often are, in process of discovery because they wanted to find all records relating to X having to do with some human services program. They weren't able to find every one of them, or at least they thought they found them, and then they realized in the closet, in the pile of tapes, there was more. And then there was more. So the court got pretty fed up and just fined the state, I think $100,000 or whatever it was. But this sort of sparked the notion that this doesn't make sense. There really ought to be a better system. And so for a year and a half or so, I and the CIO of the state, who was very interested in solving this problem, tried to work out a system and develop an RFP for a system similar, based loosely on the Department of Defense 1055, whatever, standard. But it came down to money, ultimately. Everybody thought it was a great idea. Sorry, we don't have any money. And this was even before the recent crashes. So that's an issue, of course, of sometimes you can hit on the local governments or the state governments, but they often have fewer resources, relatively speaking, to solve the problems. Quit there, share a little bit.
Thank you, James. Mark Hovit, our next speaker, is the Executive Director of the Investigative Reporters and Editors. Mark?
Thanks. I want to just make one point sort of related to the conversation this morning, because I think it's particularly important in the context we're talking about now with state and local records. And that was sort of the difference between open government initiatives and federal FOIA or open records requests. Open government initiatives and efforts by government to make information more available are of course important, but it's never going to take the place of, I think, the greater importance of making sure that the process works to allow people to request information themselves. The difference is that with open government initiatives, the government's deciding what it's going to make available and determining what's important. And when you're talking about filing open records requests and making that process available, you're letting the public do that, determining what they need, determining what's important, which often isn't necessarily what government officials might think is important, and having access to that information. So I just think that it's important to remember that making sure this process works is vital. So at IRE, we're an organization that made up of journalists, journalism educators, and we provide resources and training for journalists. And we go all around the country doing training. And pretty much everywhere we go, we dedicate a session at least, no matter what, to how to get records in your state, from the federal government. And that's because the process is difficult. It's confusing to people who don't do it all the time, and even to a lot of journalists who try to. And there are so many roadblocks that are put in place that you really sometimes have to know how to play the game to succeed. Simply knowing the law is important, but not always enough. What are some of the problems that government typically puts in the way of people, particularly at the local level? Cost. We'll talk more about that in a minute, but just coming up with prohibitive costs is just as effective as refusing to give information in the first place. If you don't have the money, you can't get it. The fact that the rules change, every state has a different set of rules. Every time the legislature gets together and gets their fingers in there, they'll change something, they'll create some more exemptions. So you constantly have to keep up to date and remain incredibly vigilant about what your lawmakers are doing to make sure that something you could get last year, you can still get next year. A couple of things that are becoming increasingly greater problems now. One is privatization, and that's that for financial and other reasons, a lot of state governments and local governments are getting third parties, private vendors, to handle particularly data for them. And then in many cases, they're then trying to say when people request that data, well, you can't have it because they have it and they're a private company and they're not subject to the open records law. And usually those battles can be won, but it's another roadblock, it's another delay. And again, especially for the average citizen who doesn't do this all the time, that can be enough to stop somebody from getting information that they really had a right to all along. Format also is becoming an issue, and we see that in several states that I've talked to journalists in recently, and that is that in some states, the way the rules read technically are that they don't have to create a special report for you. In other words, you can have the information, you can have the data, but they don't have to, if they are in a format they already keep it, or in a report that they already have, but they don't have to go to special measures to get it for you. The problem is that some places are now, say, they use a proprietary software to keep budgetary information or personnel information or whatever it might be. And unless you have that proprietary software on your computer, which most people don't, you can't open it, you can't use it. And there's some argument being made that in fact they don't have to convert that to a form, even though typically converting that information is a pretty simple process, they don't technically have to do it. So what you're seeing is sort of like with outsourcing information. If you outsource it, if you put it in a format that nobody else can open, is that going to hold up? Is that a way to take information that should by all rights be public and suddenly make it private simply by changing the rules of the game to some extent? So I wanted to talk a little bit. This conversation comes at for better or worse, an important time. There are a lot of efforts going on in states around the country right now to pull back on open records laws that have been standing for a long time. Some of you may have read about the effort in Utah recently where they briefly pretty much dismantled much of their open records law before the public actually heard about it, complained, and now they're reconsidering, but the jury's still out on what's ultimately going to happen there. But in a lot of states, including some that historically have had pretty good open records acts, a lot of legislators now are looking at making changes that could have pretty profound impact if they pass. There are efforts now to block access to text or emails from private accounts. For example, the city council person who instead of using their public email uses their Yahoo account to email everybody. Are those public documents? Well, yeah, they are, but the law has to say they are. There are efforts in multiple states now to expand response times, to add pieces to the process that allow them to delay when they have to get back to you, when they have to reply, delays they're allowed to make. And in many, many cases, that's another thing you can do to effectively kill a request. You wait long enough and the person who's asking either goes away, or in the case of a journalist, if it was a story that had any kind of time hook, sometimes you can just wait it out till the next story comes along. They're making information that's previously been public-private. In a number of states, employee dates of birth are becoming a big issue. And in several states, they've changed the law to make those no longer public. In one particularly interesting case, there's an effort going on, which is now in the courts, to say that you can no longer have state employees' dates of birth. And the reason this matters, from a journalist perspective, for example, is that say that you've gotten a story, for example, that there's a felon working in the Parks Department, and their name is, John Smith. Well, there's a lot of John Smiths, but if you have identifying information, you might be able to use that to determine if the person you're looking at is really the person you're writing about. So allegedly because of identity theft and other reasons, there are efforts to take that information away. Some of the same states that are working to pull that information will still sell things like voter rolls, which include every citizen's date of birth on them. So they're perfectly happy to make money selling your date of birth, but if you work for the government, suddenly there's a risk of identity theft. And other situations sort of along those lines. One thing I sort of wanted to talk about, given the nature of today's event and where we are, is sort of where state and government records collide. It sounds like a reality show, where state and government records collide, federal records. Because a lot of what state does, it does at the mandate, at the requirement, or using funding from the federal government. There are plenty of state agencies that gather information, that produce reports, that are then submitted to federal agencies. And oftentimes in these situations, you can find yourself sort of in this no man's land where you can call up the state agency and say, I want this report that you generated. Oh, we did that for X federal agency. You'll have to go to them. You call up X federal agency. Oh, the state put that together. You'll have to go to them. And you get knocked back and forth and again, more delays. And even if you ultimately get the information, who do you get it from? What does the law say? So there's a couple of suggestions just that, along those lines that could help. One is that anytime a federal agency is requiring the state to do something, whether through a mandate, whether it's because they're funding something through a program, sorry, I was distracted for a minute by my hissing or whatever that is. Lunch, I apologize. that anytime the federal government is requiring a state agency to gather information, part of the requirement should be that whatever is gathered is a public document, unless there's some specific reason, exemption-worthy privacy information about an individual that makes it otherwise. And penalties should be built in to say, if you refuse to give this information up, you face financial penalties, whatever it might be. In other words, the federal government could, through the money it provides to states, provide sort of a requirement that that information that's gathered is available to anybody. And I think that in many, many cases for a lot of important programs and a lot of important data sets, that could help make that information available. Similarly, outrageous fees. As I was mentioning a couple of minutes earlier, what you find is that, especially for people who don't deal with government regularly, you'll make an initial request to a local government for something, and immediately the cost comes back as something outrageous. That's going to cost thousands of dollars. It would be incredibly difficult. But if you want to pay it, that's fine, knowing that 90% of people who make records requests, the minute they get a bill like that, go away. Some journalists typically know better and know that sort of going to state or local government and sometimes federal government for data is kind of like going to a flea market. You never pay the original price, right? You got to barter, you talk them down, and usually what you can do is you can eventually, if you know what you're doing, get the price down significantly, but it's a lot of time that shouldn't have to be spent, and once again, if you're not familiar with the rules of the game, you often don't know that you're supposed to play in the first place. So once again, for data that is required to be gathered by the federal government through the states, there could be requirements stating that either that come up with either a reasonable set of fees, could be based on, in some states have caps on what they're allowed to charge, some don't. So in states where there are caps, there could be requirements that they have to not only stick to those, but provide anybody who asks for information a detailed report on what it's going to cost, because the minute they have to justify the expense, typically it drops way down. Yeah. What's that? Ah, I'm sorry. Okay. Well, I'll stop talking now and then I'll turn it off. Okay. All right. That's a good enough reason to stop it.
Thank you, Mark. Although I'm not sure outrageous fees are strictly the purview of state and local governments.
Oh, no. I didn't mean to apply that.
Okay.
No.